Thank you, Lindsay, and good morning, everyone, and welcome to our panel. I'm excited to be moderating this panel because typically I am not good at public speaking. So I appreciate Affordable Housing Professionals of New Jersey giving me this opportunity to really increase my skills at this and present this very important topic. My name is Samantha Hennessy. I am a board member with AHP NJ. I am also a affordable housing developer with the Alpert Group. I've been developing affordable housing for many years. I see actually one of my mentors is an attendee today, Barbara Shore, so I hope I do her proud. But just to kind of start, I was hoping that maybe Ed Schmier was able to join us this morning and talk just a tiny bit about Affordable Housing Professionals New Jersey. So I'm happy to sort of take that torch from him. Affordable Housing Professionals of New Jersey is an organization that's really been in practice for a really long time. We've had members over the years, Barbara Shore, Adam from Fair Share. We also have Josh Bowers, who's on our board currently. And we have just a host of folks from all facets of the affordable housing industry. So Gail Pfister, who has been on our board for many years, used to run our program committee, and she has passed that torch on to Brian Rappaport, who worked to really bring this seminar to you folks today. And so I'm excited that Brian stepped up because Gail has done a wonderful job over the years with the program committee. But Affordable Housing Professionals New Jersey, if you are members, or if you're not, I would really encourage you to join because you get access to great panels like this and also to information that's so important to our industry and to things that are going to be happening over the next couple of years, which you're going to hear about today from Michael and Christine. So I will let them get started in a moment. I would just like to introduce them. First, we all know that affordable housing is a very important topic, and it touches every single person in New Jersey, from the industry professionals like me to the homeowner that has a site that's been listed in a settlement agreement as a potential opportunity for affordable housing, and most importantly to the folks, thousands of folks in New Jersey that are desperate for affordable housing. I get calls and emails every day, and it's heartbreaking to not be able to give folks the answers that they need where they can find affordable housing. So I'll introduce the folks for this panel. The panel that we are discussing today is the fourth round of affordable housing obligation. I think many of us are familiar with how we've gotten to this point, and Christine and Michael will speak to that. But we're coming up on the third round expiration in 2025. So towns really need to start preparing for how they're going to get their next round of obligation to move forward. And I think, and we'll hear from these guys, what's been done. Are there still a lot of sites out there? Have these settlement agreements really come to fruition the way that they've been structured? Michael Herbert is a shareholder with Parker McCay. We're very excited to have him. Him and Christine penned an amazing article. If you guys all have time to read it, I suggest you read it, in the League of Municipalities at the end of the year, specifically speaking about the fourth round obligation. Michael is I would say a tenured land use attorney that who has been involved in many aspects of affordable housing and market rate development as well. But we're very excited to have him share his experience with this important issue. And Christine Cofone is a planner. She has a master's degree in planning. She's been involved in numerous settlement agreements. She's a special master that's been appointed by courts to help towns get these affordable housing settlements in place. So I will turn it over to these guys. I don't know if they want to share a PowerPoint or if they really want to start just the discussion, and then we will have a Q&A after. Thank you.
Good morning, everyone. I am Michael Herbert. Again, as Samantha stated, I'm a shareholder at Parker McCay. where we have an extensive municipal and land use practice, and we also specialize in affordable housing. She mentioned the article that was circulated. I have to give credit to Linda Galella of my office as well. She and I wrote it together. I see that one of the other partners is on, John Gillespie. He's not on the byline, but he was also assisting in this, along, of course, with Christine. So if you get a chance to read the article, it does really help you with regard to what's going on with the next round. So we're going to begin with a PowerPoint. Do we have the PowerPoint up? I'm sorry, Christine, you should introduce yourself as well.
So good morning, Christine Cofone. I am, as Samantha indicated, a professional planner. I've been practicing for 28 years, predominantly as an expert witness, many times representing developers who want to build affordable housing. But I am also an affordable housing special master. I had the pleasure of participating in 2 of the trials, the South Brunswick trial and the Princeton trial. And then subsequent to that, many settlement agreements for the 24 municipalities I sit as special master. So there's a lot of interesting things that go on. I know what we are all here today to talk about is what happens in the next round. So some of the beginning slides in the PowerPoint presentation are a little bit of preaching to the choir, because I think everybody on this presentation sort of knows how we got here, but we'll certainly go through that for a little bit. We'll touch on that. It's always good for a reminder, but I think everybody in the industry is really buzzing about what comes next and how, what is the next round going to look like? And we as advisors, planners, attorneys, and otherwise, we as advisors to our municipal clients and to our private sector clients, how should we be telling them to get ready for the next round? And while we don't have a crystal ball, what we're hopeful today is that we give you some clarity and just some things to start thinking about, regardless of what seat you sit at in this table, of how we can continue to create and produce affordable housing in this state. Because as Samantha said earlier, there's a tremendous need for it. We have made some great strides, but there's still much more work to be done. So hopefully everybody comes away from today with at least a little bit of clarity and perhaps a short list of things that we can do and advise our clients to continue the good work that has been done to produce affordable housing that's so needed in the state.
Thank you. So is the screen being shared with the PowerPoint yet? There we go. Okay. All right. If we could go to the can we control, or is that you, Samantha?
It's me, but I can, just tell me next slide and I will.
Next slide would be great.
Can you see the next slide?
Yes.
Yes.
Okay, so with that, we'll start with Chris. Yeah, just keep it. There we go. Christine, we'll go ahead and go over the affordable housing obligations.
So what this slide really just talks about, and this is, again, like I said, a bit preaching to the choir, is that every municipality in the state of New Jersey, excepting urban aid municipalities, has a constitutional obligation and a number to provide for affordable housing. The obligation is based on a calculation of statewide needs, and I was fortunate to participate in the Princeton trial, where Judge Jacobson appointed Richard Redding as a numbers master. So that to me was one of the most helpful things that was done in this round, because what it really did was we were sort of a rudderless ship, and we didn't have a great map as to how to come up with the number. And then that provided really a springing off point for many of the communities, not just in Mercer County, but that was adopted then far and wide throughout the state as the prevailing methodology. So that was really the first step. And then we got our numbers, and we were off and running to the races as to try to come up with settlements to meet those obligations. You can go to the next slide, Samantha. And as a matter of housekeeping, is anyone at all being disturbed by our Yorkie in the background? Does anyone hear her yapping away? I hope she's not being too disruptive.
Can you hear her, Samantha?
It's okay. It's very minimal.
Okay.
Why don't I go get her?
Go ahead. I'll do this.
Okay, so we want to ask, how did affordable housing come about? And it's through a series of court decisions. Under the New Jersey Constitution, there is a certain housing obligation, and it began back in 1975 with Mount Laurel I, which stated that every developing municipality has an affordable housing obligation. And as many of you know, prior to this decision, there were allegations that many towns were zoning in a way that, and doing things in a way that prevented affordable housing from being located in those towns. And the courts found that, hey, every town, you have an obligation to provide affordable housing. It's not just supposed to be in the cities. It's not supposed to be in poorer municipalities. Every town has an obligation. I represent West Windsor Township, Hopewell Township, and Ewing Township, and they have a variety of socioeconomic challenges and highlights. And each town has its own requirement. And I was part of the trial as well before Judge Jacobson with those towns, and we were able to get. I think Ewing Township we were the first in Mercer County to have an affordable housing settlement, and we've been very successful there. And Hopewell came soon thereafter. West Windsor was after the end of the trial. So I've also been involved in other counties as well. In Middlesex County, I represent Plainsboro Township, where we were the first one to get an affordable housing settlement. And both Ewing and Plainsboro were very proactive in how they set themselves up for affordable housing, so they were successful. So come 1983, you had Mount Laurel 2. Actually, my father was one of the arguing attorneys on that matter. And in that, the court ruled that every municipality has an obligation, and those in growth areas, and this is where growth areas first came in, have an obligation, have a greater obligation than those in non-growth areas. Everyone is familiar with the big red map that the state has produced, and there are certain areas of New Jersey, including really the middle belt of New Jersey, as it runs along both the Turnpike and 95, as well as some areas up in North Jersey, that the state sees greater growth than, say, the Highlands and the Pinelands, who are partially preserved, and because shore areas with CAFRA and those kinds of things. So each area has its own obligation, and that's really what Mount Laurel 2 focused on. 1986, the court again ruled in Mount Laurel, which is now called Mount Laurel 3. It was called something different back then, but it's now called Mount Laurel 3, which affirms the validity of the Fair Housing Act, which was adopted by the state in 1985. And again, in that, the act really is a reiteration of the Constitution, states that everyone has a right to housing and a right to fair housing, and not to be discriminated against in where they live. Finally, we have 2015. That's the Jacobson, which spurred on the Jacobson trial. This is the New Jersey Supreme Court stating that COA, which from 1986 had been constituted, but that COA was dysfunctional. You'll remember that through a series of governors, COA was appointed, and for a while it was functional, and for a while it did work. But later on in its age, it became dysfunctional. According to the court, it became dysfunctional and was not accomplishing what the court thought it was constitutionally required to do so. So COA was found to be dysfunctional, and the court stated that they're going to take over the certification process. Now, many of the counties then started up trials through the through the declaratory judgment action that was filed by many of the towns. In Middlesex County, Judge Wolfson moved ahead, and we had several settlements there, but no real trial occurred until we had Judge Jacobson. And Judge Jacobson heard the matter. It's called In the Matter of West Windsor Township, but it really involved many of the Mercer County municipalities, including Princeton. It was a 41 day trial. Yes. 41. It was a very long trial. If you love hearing about numbers, that was your place. I went to law school because I'm not great with numbers, and it was a little tough for me. But it went on. We had the experts, and the experts testified, and the judge issued a decision. Quick funny story. When the decision came out, it was 263 pages. And we had to drive out to Lancaster the night of the decision, and my wife read it the whole way out.
We were on our way out to a swim meet.
Yeah.
Where if we're not practicing land use and affordable housing, then you'll find us at a swim meet. That's pretty much life as we know it. So yes, so that's a great segue to the next slide, Samantha. So
I think we should probably do a polling question, Lindsay, before we go to that next slide. So, polling question, are you interested in learning more about municipal government related affordable housing law and policy? Yes, no, unsure, not applicable.
I'll give it about a minute.
Okay.
You can feel free to keep going if
This
you.
is the first time I'm taking part in one of these where I have a poll.
me too. It's interesting.
Well, interestingly, it is the legal credits that require
I see.
this method. Yes.
Usually when I'm doing the ICLs, we have a number that everyone has to take down and then enter.
Yes.
So
Oh, interesting. Okay.
So again, this is a bit more preaching to the choir, because at this point, I would imagine most people who are participating, most people who are participating in this seminar know what the obligation is described of and constitutes. But when we're doing our settlements, the first step is to really look at your prior round. And in some cases, there's a deficiency from the prior round. In some cases, some fortunate municipalities who were good faith actors actually had credits to carry over from the prior round. If you had done a good job of meeting your obligation, then you had surplus credits to bring into this round of affordable housing. There was the rehab component, or the present need, which is looking at your housing stock and seeing where there's opportunities to upgrade that housing stock. Many of us who have either prepared spending plans or approved spending plans have looked at funding that program through our affordable house trust funds. So that's, you're really not creating any new units there, but what you're doing is you're bringing units into better standards with that component. And then there's the prospective need, which is really the meat and potatoes of our plans that we've seen. And that's new units that were required between 1995 and 2025, which includes that gap period that we'll talk about. And the prospective need was really, it gains the most focus because that's what required municipalities to select sites and to put the zoning into place. So that's where the intervener process came in, where most of us had communities that had multiple interveners vying for seats at the table. And in the communities I represented it, I likened it to like a beauty pageant where they would all have to come. Branchburg had a really interesting process where they put out an RFP, and we had probably 10 or 11 responders and everybody wasn't going to get a seat at the table. And, we had some pretty contentious meetings at the courthouse with Judge Miller, and we would start the meetings by saying, you all responded to the RFP, you chose to be here, everybody's not going to make it into the plan. And when I say, beauty contest, what that looks like is, the sites that are the most appropriate for development that garner the most affordable housing. And I think what we saw in that round was, in many instances, sites were looking to put in greater than 15%, greater than 20%, greater than 25% in some instances to get a seat at the table. So segueing that into what that's going to look like in the next round, I am certain that some of you on this call, on this seminar, have been on the other end of phone calls where those projects that were inked in 2015 and 2016 and 2017 as part of settlements were done in a very different climate, meaning you have had since that time a global pandemic. You have seen interest rates rise. You have seen supply chain issues. So all of these projects that were inked with a set aside greater than the 15 or 20% to get a seat at the table, in my opinion, in the fourth round, just based on some of the phone calls I've fielded already in some of the towns where I sit as special master, we know that those projects and the viability of those projects that were contemplated years ago are going to need to be looked at again because of those things. Like I said, the interest rates, and in the next round, I think perhaps we will be thinking of that and thinking, I know when we did these plans, I can assure you that in the 24 communities that I sat in before the pandemic, that supply chain issues and spiking interest rates were generally not contemplated in some of the plans. So I think as we think about our prospective need for the next round, I would imagine that many of us will be looking at some of our sites that were included in this round that may not have continued viability. So the next slide, please, Samantha. What is the gap? And again, like I said, I think again, if you're on this seminar and you don't know what the gap period is, welcome to the industry and welcome to the profession. I hope that you are enjoying it, because I trust that all of us know that the gap period is really the affordable housing obligation that was generated between the period of 1999 and 2015, when COA really wasn't functioning. While COA wasn't functioning, the obligation and the need for affordable housing didn't go away. So that was really just
And we municipal attorneys really argued hard that the gap should not be part of all the trial, and that should be something totally separate and something that was really being dealt with by COA. But Judge Jacobson did not buy our arguments, and so therefore we now have the COA gap. I'm sorry, the gap obligation as well.
This is just a slide. I'm not sure that these numbers are the most fresh and current, but what this is, that this just indicates that the majority of the towns who filed DJ or declaratory judgment actions back in 2015 have settled. So, which means that they came to a settlement with Fair Share Housing Center with regard to what number they were going to solve for or plan for. And to date, there are only a handful of municipalities that don't have signed settlements, South Brunswick being one of them, although we are still operating and things are happening in South Brunswick. I have the good fortune of being the Affordable Housing Special Master for that district. So we are working and we are moving forward, although we do not have technically a settlement agreement with the court. In that process, it's been a little interesting. I know from looking at the participant list that some of you are participating in that. That's been a little different. South Brunswick actually lost their immunity. Judge Wolfson revoked their immunity. So the projects in South Brunswick have been proceeding through what's called a special hearing officer process, where instead of the planning board in South Brunswick hearing them, the special hearing officer has been hearing them. And it has been working quite well to move things through the process, at least to the approval process. And some of the projects, I believe, are getting near to the point where they're ready to pull building permits. So I can't say that nothing is happening there.
Although I do like to use South Brunswick as an example, and I've got a lot of good friends as well over in South Brunswick, so you have my sympathies, but they are a good example to use with the other towns as to what can happen if you do resist the what is going on within the courts. So it is a way to persuade your towns to try to participate in the process in the most upfront way. Go ahead.
So the point of this slide is that the lion's share, fortunately for the affordable housing community, the lion's share of municipalities in the state of New Jersey did participate in the process, which resulted in a substantial hundreds of settlements to aid in the production of affordable housing. So while not a perfect process, the process is working.
And I do represent some towns where they do not have a settlement in place, usually towns that have a lot of affordable housing as part of them, and they've chosen not to participate in the process because they do not believe that developers would be filing lawsuits against them. Some have found otherwise, and I am assisting those towns now in trying to enter settlements with fair share housing. So if you are part or of a town that still is not part of this process, please try to persuade them to engage, especially with Fair Share, who does a good job, especially with these kinds of towns that don't have a lot of money, for this process. But you want to have that protection from developer lawsuits that this litigation provides as part of a shield. So those are moving forward, and then this is a nice segue to what we're going to talk about next, which is the fourth round. And even those towns have to have an eye for the fourth round, and that's why we're trying to get them settled now so that they're ready for the fourth round.
So I think this is a sort of good segue for our next polling question, Lindsay. Do you think municipalities need to start preparing now for their fourth round affordable housing obligations? Yes, no? It depends on the municipality.
I think more yes than no.
Being that we are the married duo of a land use municipal attorney and a planner, special master, yes.
We're gonna go
Most
with yes.
definitely yes.
You let the cat out of the bag. I didn't share that information, but I think it's wonderful that you guys work on this together.
We actually
and still get along and are still married.
Yes.
we met at a planning board hearing, so
Yes.
Wow.
that's the kind of nerds that we are. So anyway, going forward, you should, there you go, 87% yes.
Good, see?
All right, who's the 1%? I want to know that person.
Who said no?
Listen, a lot of towns are afraid to participate, not a lot, but some are, to participate and start planning now because of the expense. It is expensive. Yeah. It is you have to put a lot of money in, and the public, there are a lot of members of the public and politicians who believe the whole process should be thrown out, and they don't want to be part of this process. But look, this is the reality. This is what we have in the state. It's not going away. It's not going to be solved anytime soon by legislation or administrative action or anything like that. It is what the courts are going to move forward with. So in the end, while you have to, it's like the old Midas commercial. You can pay me a little bit now, or you can pay me a lot later. Mm-hmm. If you start planning now, you're putting everything in place that you can. And I gave examples of two towns I represent in Ewing and Plainsboro who really worked hard to plan for the future. And that was recognized by the courts. And it was a much more reasonable, from a price standpoint and an effort standpoint, process to engage in the third round. And they were both very successful towns. They were two of the first towns to settle. And I think if you talk to those towns, they will tell you that they've saved a lot of money by being proactive, planning quickly, and putting the money and effort in before the obligation hit. So I would say the one person that voted against it, please think about that again. And for most of you that voted for it, I think will be in good shape. Your towns will be thankful for it.
So as far as what the methodology is going to look like, I mean, we're starting the next round with the benefit of the round that would have ended in 2025 when we actually do commence the next round. So we should be light years ahead. We shouldn't have to hopefully go through another numbers trial. So you'll have your baseline numbers. Samantha, if you can go to the next slide. So one of the things I think will be very helpful to municipalities in their next round is their midpoint review. Presumptively, most of you in 2020 did your midpoint review. Many of the people on the seminar today probably were responsible for preparing that review. And what that midpoint review was, it was, and again, some of you may have settled in 17 or 18 and then did your midpoint review in 2020. But what the point of the midpoint review was to be, it was supposed to be a check-in point, right? In a period of time that's a decade long, it makes abundant sense to take a point in time and check in and say, well, where are we? We said we were going to rezone certain properties. All of those things, those compliance mechanisms and things that you were supposed to do. Did these things happen? Did the planning boards, did the applications, it can be sometimes the municipality has done everything they need to do. They've put the zoning in place. The ordinances have been adopted. Everything has been done, and the developer hasn't filed the application. The municipality can't compel the developer to file the application. They can only put the zoning in place. So the midpoint review gives us an opportunity to check in and see where we are. So if I'm advising from a municipal planner point of view, or if I'm advising one of my developer clients who would say, oh, can you check out XYZ municipality and see where they are in the process? Did they do everything they said they were supposed to do? Are they meeting their obligation? Or is there some exposure there for us to get a foot in the door? You know, one of the first things I would say to look at for the communities looking at your next round is look at your midpoint review and see what you have and have not accomplished. That's going to be a great jumping off point. The next slide, Samantha.
And remember, everyone, July 1, 2025 is actually not that far away, and you want to be ready for that date. so that your town attorney or your affordable housing attorney can go ahead and file the next DJ action, declaratory judgment action, to maintain your immunity. You don't want to lose that immunity. You lose the immunity, you end up with a situation like South Brunswick, where you have a lot of development that is forced, literally forced down your throat, and it is not a good situation to be in. You will not be popular with your public, even though they may be mad about participating in the process. It is just something to keep an eye on. So really, you should start, as the poll said, we should start now. Start getting ready for that round, looking at those properties that may not have come online, as Christine was saying, and seeing what else you can do. I have several towns where, for instance, one of my towns has a large athletic center, tennis center kind of thing, and in that town, the whole center has gone belly up. It's financially ruined. It's being foreclosed upon, and I've said to the town, hey, take a look at this property. This may be a property that we could use in the next round, and even maybe do a 100% affordable housing project on that property that would fit nicely into our fourth round plan. We have both talked to judges who are involved in this process. Even though Judge Jacobson's decision is only controlling in Mercer County, everyone else is pretty much following it. If you do have time and you want to read the decision, I do advise you read the decision so you understand the methodology that went in there. But the judges are most likely, and again, this is not guaranteed, but most likely going to be following that decision for the next round. So you can start looking at that decision and deciding, hey, here's what we need to do. Here we have a site here that may work better. All of these plans are living plans. They can change as the circumstances change with them.
That, I think, is one of the key components, is that, and you can go to the next slide, Samantha, if you will, please. Thank you. Is that they're living plans and they're living projects, because the other thing that we have seen impact some of the plans is the DEP regulations. Well, what we well know is that when many of these plans were inked, they were done off of concept plans. And we have seen a concept plan appended to the settlement, and that concept plan did not have the benefit of engineering. It did not have the benefit of more complicated studies to see, can the site really generate the amount of affordable housing it's been put in the plan to produce. So as the DEP rules have only gotten more stringent since 2015, right? We had a few years ago, we had new rules put out for the DEP, that impacts the production of affordable housing, because certain sites were put in plans. And I know with 100% certainty that there are plans that I have been involved with that are realizing shortfalls as a result of those DEP. So it is, I don't want to say that it's a shell game, but it's definitely, you have to be fluid and you have to be able to be flexible in the process as to looking at the sites that you contemplated. Are there other options? Is there opportunities to create more density on other sites, to go 4 versus 3 stories? There's things that you can do and be flexible in the process, looking at your sites to move things around. So I think that's a good thing to do now. You can certainly start doing that now. Or you very well likely know if there are sites that you put in your plan that are not going to be able to produce because you now have some more information, then you can start looking for new sites. It's definitely not too early, in my opinion, to do that.
And remember, with the new DEP regulations, which really do shrink a lot of these projects and even knock some of them out, that you have to be flexible. And one of the ways of being flexible is to use the redevelopment process. And that is the one tool in the toolbox that really can help a town attract a developer to come in and develop a property and provide those affordable housing units. Remember, 100% affordable housing projects through, and we'll talk about that, but through a lot of the public financing that is out there, and there's a lot of money out there right now to be used, are perfect. Remember, they can only be part of your plan. They can't be your whole plan, but they can be part of your plan. But they really help get your numbers in a place that are much more easy to swallow.
So next slide, please, Samantha. So a few weeks ago, I had the good fortune of participating in another ICLS seminar called VLA adjustment. Do you need to wait to 2025, or why wait till 2025? So VLA, vacant land adjustment. And again, if that's a new term to you, welcome to the profession and welcome to the industry, because the lion's share of us who have been practicing since 2015 or before, in most of our cases, we know that a vacant land adjustment is something that a lot of towns went through, where, say, for example, because like many others, I am also not a numbers girl. So say your obligation was 100 and you did a vacant land adjustment because your municipality could only produce 50 units. That leaves you with an RDP of 50, and then that's what you're solving for. The rest becomes your unmet need. So the presentation that I did for ICLS a few weeks ago with some other attorneys and planners was about, if you're, and this is just to the vacant land town. So for those of you who don't have any dogs in that fight, I apologize. This will be a good time for you to check your email. So in the vacant land towns, and the subject of that seminar was, do we need to wait till 2025? And the general consensus was that you don't. And I can tell you, I sit as the special master in Hawthorne, and at the very beginning of the year, this year, we had somebody who brought an action, who wanted to look at a site for the production of affordable housing that was not listed in the vacant land analysis. Now, it was contemplated by the municipality, and it was ultimately decided they didn't put it in because it had contamination issues. It would have required a substantial cleanup, and Judge Rogan actually did not let it into the case. But this is the type of situations that I think you see and you hear about, is that what happens then if there's a site? What if the site wasn't dirty? I think if you had an opportunity to read the Drew Madison decision that Judge Hansberry came out, if you were looking at that decision and we were guided by that, then we would have to conclude that you need to look at it. You need to let it in. You don't need to wait until 2025. So I am of the ilk that if it's a town where I'm sitting as the master in, and someone presents me a site and says, I think we do have an obligation to consider it, right? That's in a vacant land adjustment town. If that was missed or overlooked or somehow, and if you again read the Judge Hansberry decision, he really wasn't persuaded by why it wasn't in the matter before him. He really looked at, or at least my interpretation of his decision was, the site's being presented now, and this process is supposed to culminate in the production of affordable housing. So if we're presented with the site and it's a viable site that meets our ABLEs, suitable, available, developable, approvable.
Yeah, it was just decided.
It was decided, I believe, earlier this year. I can certainly send you, I can send you the decision. I can give Samantha the decision. And however, as we know from the earlier chatter before the seminar started, IT is not my strong suit, but I can send Samantha Judge Hansberry's decision, and she will get it out to you for those of you on the panel that don't have it. But I think it was a great read, because really, for those of us who our practices, at least partially devoted to the production of affordable housing, my read of the decision was the judge wasn't particularly persuaded as to if somebody was withholding a site, or the issue before him was the site is here now. So what we're going to do is we're going to deal with it if it's a site we can use to produce affordable housing. So as the towns that I sit in as master, I take a similar approach to that. And if somebody reaches out to me, then I feel as though I have an obligation to the process to say, okay, why was this site not considered? Was it missed in some way? So, and I know that this is not a seminar on vacant land adjustments, but it is a seminar on the next round. So if you are a vacant land analysis town, a VLA town, one of the exercises that I think would probably be prudent for you to go through is, in addition to looking at your midpoint review, is to look at your VLA and see what went in it. Have you had any sites go dark since then? Like Michael said, he has a community where a tennis center went dark. And I said to him, sounds like a fourth round site to me, right? So those are the things that you should be looking at, in my opinion, is your vacant land. It's absolutely, in my opinion, not too early to start that process, because I think you don't know when you're going to get an email or a phone call that, hey, I have a site that I think is appropriate. Should we consider it? So I think, go ahead.
Yeah, I another town I represent has a number of wrecking yards, and these have been eyesores for many years. At the town meetings, you constantly have people coming up complaining about these places. They're just a source of real problem. And what we did is that we declared every one of those wrecking yards an area of need of redevelopment. And those are in our plan for our affordable housing units. This town has a huge number that it's got to be able to take care of. And so we were able to kill several birds with one stone. We're going to get the sites cleaned up. We issue a pilot, a payment in lieu of taxes for a developer who wants to come in and clean up the site and then provide affordable housing on the site. So it becomes a win-win for everyone. Developers are looking for places to put in housing. Towns are looking to get rid of eyesores. Neighbors are looking for someone to clean up contaminated properties next to them, and pretty much every wrecking yard is that. And so everybody wins in the end. I mean, you may get neighbors that are not happy that they're going to have a housing development and a higher level of traffic. That's always an issue. But these are how you can persuade, and really we're in the art of persuasion, how you can persuade a town, its people, and developers to all work together to provide both affordable housing and maybe take care of some of the town's issues.
Did you want to do a poll, Samantha?
The next two poll questions, I think, are a little bit more geared towards affordable housing professional of New Jersey questions. So we can keep going, I think, with your slides at the time.
I do just want to remind participants that they should put their questions into the Q&A section so that when we get to that time, your question is ready and can be addressed.
Yeah, you'll when Christine was talking about the Drew College decision, that's what we're referring to. A question came in, and so if you keep the question and answer box open on your screen, you can see as the questions come in. Maybe those questions will spur on some questions as well.
That's a great point. And I have a couple questions, but I will wait till the end.
Great.
Okay, we're almost at the end.
Okay, so the next thing is plan out strategy, and you all are going to have to report to your governing bodies as to what we're looking at and what we can do to solve it. There are many out there. Several of my towns, my elected officials say, hey, I heard that the legislature and the governor are going to bring back COA, the Council on Affordable Housing. That's coming back and they're going to take care of it. The legislation has been pending for some time now. It is, some would say, the third rail of politics, and most politicians on a state level do not want to touch it. You have a general path right now where the focus is elsewhere on other things, and there's a belief that to try to bring back COA at this point would cause probably more grief than it was worth. So if you are a town that is depending on our legislatures or our governor to solve this issue, you better look elsewhere. It's going to be the courts. That's just the way it's going to be. Look, I am hopeful, and I would love it if COA was reconstituted and that we're able to get into that process in a legitimate way. I think it would be good for the towns. Developers may not be as happy, but I think it would be good for the towns. But it's not coming back right now, and so don't depend upon that. It's if you get a mayor or a council person or somebody like that's telling you this is the solution and we don't have to do anything, tell them that's not the case and that they must plan ahead.
Well, I mean, none of us have a crystal ball, right? So I don't think we can actually say and sit here with absolute certainty that we don't know that COA is coming back or not coming back. But as planners and as affordable housing professionals, I'm not sure that much matters to us, because if you look at the second round, when we had affordable housing plans, the process for the affordable housing planners and the planners is the same. Whether we're solving for a particular number, we're still looking for sites to produce affordable housing. We're still looking at alternative mechanisms. We didn't talk much about that today, but there are other group homes, assisted living facilities, other things than traditional inclusionary projects. Veterans housing, that's something that we've seen in this round, a preference for veterans housing, special needs housing. So these are the type of things that regardless of we're with the court systems or a COA is in fact reconstituted, as an affordable housing practicing professional, I don't know that that has, certainly it will impact the process, but I don't think that that is a reason or a motivation for us to be not looking towards the next round. I think you have to look at your plan and look at what worked. I had a community where I was representing the developer on a use variance to create what is really an extension of a project that was approved in the second round, and it was wildly successful. They have had almost no issues with the project. The project just kept up beautifully. There's a waiting list for the affordable housing units to get in there. It's really just, it has a lovely clubhouse, beautiful maintained gardens in front of it. It really has been a great partnership for the developer, for the community, for the people who live there. So the developer was able to acquire land next to it and go for a use variance to get additional housing created. So I think a lot of planning for the next round is looking at what worked, looking at what didn't work, looking at being creative and coming up with solutions, right? We know we can do part of our communities with senior housing, part of our community with assisted living beds. We see that present in some municipalities. Group homes have been a good solution for meeting the very low income. Right. In this round, we have the very low income, which is, we didn't always have to deal with that, right? Decades ago, when we were doing our plans, that wasn't a component to them. So it is now. So I know in some instances that obligation has been satisfied. If you have a project that's a for sale project, it's very difficult to meet the very low income on site in a for sale project. That creates some practical difficulties in getting those units saleable and occupied. So the workout in that, in more than one project that I've been involved with, has been solving for that in a group home off-site. So again, we could stay on this seminar till 5 o'clock talking about all the different ways and what that looks like. So as a community, I think it is prudent for you to start looking at those things now so that you can get ahead of it. Because as Michael said, it's more costly, or in most instances, it's more costly to delay and not do that. You spend more time litigating and more time having your professionals, go do and redo things. But also we've seen things too with the early on solutions where they weren't vetted enough and the environmental constraints weren't really considered. So you really do have to walk that balance and take the time to look at the sites. And I think starting earlier gives you a leg up in doing that.
And it's also a way not to have as big an obligation that you're stuck with, like some of these communities we're talking about. If you plan ahead and you're proactive, Fair Share Housing Corporation sees you're proactive, and the court sees you're proactive, usually you can have a smaller number as well. So not only is it cost benefit to the town, there is also a benefit as to your numbers.
That's a good segue to a question that I have for both of you and has come up. You mentioned funding for affordable housing that's come out, and as a developer, I'm well aware of the funding that has come out from HMFA called the Production Fund. It's really funding that was set aside from the state in order to access this funding. It's about $305 million. You have to be in a settlement agreement to access that funding.
Yeah,
so,
I'm doing a project right now down in Burlington County for veterans housing. And if you're not in that settlement and it's not set to go, you won't get that funding. So it's important you have these things set up, as you said, ahead of time. Have that planning in place, have all those things in place, because otherwise everyone else is going to get the funding and you're not, and you're missing out on a lot of money.
And you need to have the settlement agreements in place. We're dealing with that in South Brunswick, where we just had a request. I just was on the receiving end of a request this week for a developer who's looking for an additional distribution from the trust fund in South Brunswick. And had South Brunswick had a settled plan, they would be eligible for additional funding, which they're not because they don't have a settled plan. So it does create
what is your advice for something like that, where you have a town that maybe is having an issue meeting some of the need in their settlement plan. You have a developer that has a site that they would like to do a 100% affordable housing project. Can the town amend their plan to include this project, or do they need to wait until the next round?
No, they can amend their plan. My advice would be to contact Fair Share Housing. Adam Gordon is wonderful to work with. If he sees you making an effort, as well as everyone else down there, and you say, look, we've got a change. This is what is being proposed. What do you think? Usually he'll sign on if it's legitimate. He'll then assist you. We'll go ahead and put together an amended settlement, present it to the court. The judges are always very happy if you walk in there with Fair Share Housing at your arm, at your elbow, and you go ahead and have the court sign off on the amended change. And again, this is a way to plan for the next round as well.
And it's really just a partnership. I think some of the ways I've seen it done, if everybody is in agreement, if the developer is in agreement, Fair Share is in agreement, the municipal host community is in agreement, I've seen it done by consent order. And that's if it's a site that was, because we've seen this come about a bit. If it's a site that's already in the plan, and you're looking to perhaps just increase the density because you realize that the topography is such that you're going to require blasting, so you can't touch this, so you need to increase density on that site to get where you need to get for your plan. I've seen things like that done by consent order, where Fair Share is in agreement, the town's in agreement, the developer's in agreement. Some of the trickier things we've seen come up is, even if everyone's in agreement and you have a site that wasn't in the original plan, do you have to go back and formally amend your plan and amend your housing? Because presumptively that site was not vetted through the process as being a site that's suitable, available, developable, and approvable, right? So then, in my opinion, that would constitute you having to go back and look at that plan again, because it's not a site that was initially contemplated. But I think we've seen many housing plans amended over the years, and I think a consent order is a great way to do it if everybody's on board and you have a judge that's ready, willing, and able to just try to help move things along. We've seen things done just by consent order, where you prepare the consent order, the judge enters it, and you're on your way, and you get to do the modification. Some of the more complicated ones that require, a new site, you're going to likely have to go and amend your housing plan. But I think, if the developer and the town are on the same page, that we have to use all our tools in our arsenal. So sometimes that means redevelopment, because you can do a pilot. And if I had a dollar for every conversation I've had about pilots, and we just don't do pilots here. We don't like pilots. The governing body doesn't like pilots here. Yeah. Okay, why don't you like pilots? We don't want to give a free ride. What does pilot stand for? Do you know what pilot stands for? Payment in lieu of taxes. A payment. The first P, the P stands for payment. It's not a free ride. You're paying. So, it's a sales job that we have to do in some of these towns just to get. But that's another tool.
And there are excellent arguments as to, a lot of them will say, well, then the schools are not getting their money and so forth. Right. But through the pilot program, the money rolls right back to the schools. I litigated this in Hamilton Township, and we've got a decision from I believe it was Judge Feinberg in that one that talked about how the money does find its way back to the schools. So there are lots of good arguments that could be made. But it is, if you want to have a developer come in and, as I was talking about, clean up a property or put in a desirable project, it has to financially work for that developer as well. So if you're a town, you go to the developer and say, hey, we really want to do this. Show me your finances for this project. You look at the finances. Does a pilot work? And that way you can go back to your town governing body and say, here's what the developer is proposing. Here is what they're going to make on the property. Here is what a pilot will do for them. I mean, there's some of these projects, developers not going to make much or anything on unless they have a pilot. So if you want this project to move forward, you want us to be compliant with the plan that we have in place, or the plan we want to have in place for the next round, you've got to be able to show, what the facts and figures are. And I think most governing bodies and mayors are financially astute, and they can, if you present it to them in a clear and concise in an easily digestible way, I think you can sell the pilot. Of course, you're gonna have the public show up. You're gonna have people grandstanding. That's just the nature of our governing and our politics. But if you can go ahead and show that in a clear and concise way, put up the charts. I mean, most council rooms have the big TVs.
Just that easy.
most we have the big TVs now in our council rooms. Put that chart up, and if you have clear facts and figures, you're going to persuade most people. Of course, you'll always have the people that say, I don't believe it, and I don't believe in government. It's just the way it is. But you can at least persuade hopefully a majority of the people.
So that's actually a really good segue for my next question. You talked a little bit about the midpoint review in 2020 that all towns that have settlement agreements had to do this reporting. Is there any more reporting that the towns are required to do after that midpoint review that by statute they'd have to share with the public?
My experience has been I've done midpoint reviews for a number of towns, and what will happen is Fair Share will review the midpoint review, and there may be some issues in there that they want continued reporting on. And so you'll be interacting with Fair Share Housing. You know, they've really staffed up lately, and they have a number of people that will work with you and also, you know, call you out to task if you're having issues. So when you talk about reporting, there's only the one required midpoint report, but Fair Share will keep requiring you to update them if things are not quite copacetic in what they want to see in that report.
A lot of that reporting has really fallen on the back of Fair Share Housing Center. They have done a yeoman's work in this, and that in the settlement agreements baked into those are when things are approved, the developer or the municipality has an obligation to continue to report to Fair Share Housing Center. So they do have quite a bit on them as far as not only getting the settlements, but then monitoring. And I can tell you, as a master, Tanu, who is at Fair Share, I get a couple emails a week on, okay, this has not been done. So I can assure you that while there may not be formal reporting, I am often copied on emails from Fair Share that they are checking that we don't have this housing element, or here's a list of what I'm missing. So in my experience, at least the towns where I sit in, Fair Share has done a great job of being the gatekeeper on that and making sure that process is moving forward, which is a staff drain on them, right? I know their staff probably takes a lot of time to go through that and rattle those trees and cages and say, but again, the process works because then you see the municipal attorney responds back with, okay, here's this. And then if not, can you give us a date of when you're going to have it? So that process is definitely occurring, at least in the towns where I sit as special master. And really the gatekeeper of that I see has been the Fair Share Housing Center.
And I have several towns. It's like that as well. Quick shout out to special masters. If your town, some of my towns do not have a special master right now. A lot of the special masters who did the last round have retired. And so there is a real need out there to have new special masters appointed. If you're a town without a special master, you know, in some towns, they don't want to have a special master because they don't want to have somebody looking over their shoulder. But it's really good to have a special master in place for the next round, so you can start working with that special master now, so that when the fourth round hits, that special master and you as a town, or you as somebody who's involved in all that's going on, have that relationship, that there's a comfort level between the special master and the town, as well as with Fair Share Housing. And in the end, you want it to be a partnership, not an adversarial situation.
And for towns that, or I guess, have their settlement agreements that were put in place, very early on, 2016, and for towns, that didn't get theirs until 2018 or later, is it still the same deadline of 2025 that they have to implement their plans?
Yes, you don't get any bonus for dragging your feet. No, because you dragged your feet. No, there's no reward for procrastination in the affordable housing process. Absolutely not. They should have to produce more units. No,
that's
and in many instances,
at least in any of the towns where I sit as special master, there no.
Well, and going back to what I said, the towns where we got the early settlements, those towns did not have to have as big a figure as those towns that drug their feet, were obstinate, even participated in trials. It's there's a real carrot and stick here. You get rewarded for being proactive. You get rewarded for wanting to do the right thing, and you don't get rewarded for dragging your feet. Maybe it's politically advantageous to drag your feet, but in the end, the politics may work at that point, but a year or two down the line, it's going to be the opposite. You're going to be in real trouble for not planning correctly, because you now are obligated for more units.
Right. So to follow up on that, it does seem, towns, it was very complex and complicated in the beginning, right? And I think we've seen these plans put in place. We've seen how they're done. So my sense is that it could go a bit smoother for the next round. But when should towns really start that process? Now, right? Even though right now.
And I think it depends on the town, Samantha, too, and what they've done, right? If you are a town who has projects literally with shovels in the ground for all of your obligation from this round, then you can maybe rest back on your laurels for another year. If you are I's dotted, T's crossed, you are issuing COs for things that were built, and you're carrying a surplus into the next round. So for you unicorns, go get your coffee and relax.
I don't know who that town is, but
right. For those of you who don't fall in that category, who perhaps are limping along to even meet what you were supposed to do from the second round, if you're in that position, or if you've satisfied the second round and you still have some obligation from the third round, and you happen to know if for whatever reason your plans are failing, right? We know that there's towns who have projects and have plans in the book, or if you have towns who, and we've seen a lot of this, who have denied their affordable housing projects. What happens to those towns where you're a community and the developer has come before the planning board for a plan, for a project that's in the plan, requiring almost no variance relief, and your planning board denies it? How are we handling that, right? So that's going to create a shortfall. So I think to the extent that should you be planning now, in my experience, for the large majority of that, the answer is yes. There are a handful of towns out there, though, who have done a really good job, and sites are under construction, built, or occupied. And if you're in that position, good for you, then you can rest back on your laurels a little bit. But I think you need to know that the fourth round is coming, and whoever, the governor over that is, whether it's the court process or COA, you're going to have an obligation. So it certainly makes sense for you to be proactive. I think, like you said, Samantha, what we did learn, we can go to school on what we learned in this last round. So hopefully it's a little bit easier. But I think in the beginning in 2015, we filled our charts and we filed our DJ actions, and probably lots of people hoped it would go away. But if anything we learned from this process is it's not going away. And if you don't deal with it proactively, you put your municipality and your community at risk to lose your right to choose where your affordable housing goes, and lose your immunity and lose control over the process. So I think certainly, unless you happen to be in the good fortune of having met your entire obligation through 2025, then yes, now is the time to be thinking of that.
Here's another question I have. So in actually preparing for this presentation, I was reviewing a few of the midpoint reviews from some towns and some settlement agreements, and I kept coming across some market to affordable requirements in some of these plans and reviews. And I don't think that that's getting done from what I hear. So I think you mentioned this before, Christine, home ownership, especially for the very low income population, is very difficult. How do we address that in the future? Is Fair Share open to having a greater percentage of rental units? Because I think that's where, we're seeing in the trends of our state and industry, what people need in general. Is that something that Fair Share will allow, is more rental over home ownership?
I can't speak for Fair Share, Samantha, because I can't, but what I can tell you is that in my experience, that as an organization, they are unbelievably fair and outside of the box and creative thinkers to get things to the finish line. I have seen them do things like look at the mix of 1, 2, and 3 bedroom units to get to get a project over the hurdle or to the finish line. So while I can't speak for them, what I can tell you is that having negotiated, dozens of settlement agreements with Fair Share having a seat at the table, that I am always amazed by their willingness and their ingenuity, right? They come up with a lot of creative solutions to get to the production of affordable housing, right? Which is ultimately what we're trying to do here, is to create more affordable housing. So in my experience, they always are on the side of ingenuity and creativity. So I would be surprised. They are a solutions-oriented organization, and I would be surprised if they would not at least consider putting that on the table, because I can't sit here and think of anything that they just say, oh, they throw their hands up and say, we're not going to consider that. They're really, like I said, a solutions-oriented, innovative and creative organization with always moving to the common goal of creating housing.
Because remember, we're all trying to go towards the same goal, to create housing for not only for the wealthy of the town, but for your local police officer, for your teacher, and for people who just have really not a whole lot of anything. And you want to be able to have that housing for these people, because you don't want to have what would be the alternative of people living in shelters, or people even in homeless situations. And every town has an obligation. Every town should want to fulfill that obligation in order to have a dynamic community.
And the interest rate issue, again, I think, each round will bring to it its own level of complexities. So I think, to answer your question, as far would they be looking at rentals, I would think as long as interest rates continue to hover where they are, that Fair Share will absolutely consider, bringing rental housing online.
That's a good point.
That is the future. And again, as Christine said, it's all about thinking outside the box. If you can really work on, coming up with creative solutions and engage the community. We always have for these town council meetings where you have a number of members of the public that like to show up and talk. I think that's sort of their entertainment for the night, but they also want to be engaged in their community. And, go to them and say, hey, do you have some ideas? You have a lot of, most communities have a lot of really, all communities have a lot of really smart people in them that, maybe people want to do good, and they want to think outside the box and advocate. And just you want to try to get as many people involved and engaged as possible, because this is not something a town can avoid. You have to take care of your obligation. The court has ordered it. It's the Supreme Court that has ordered it. It's not going to be overturned. It's not going to be, as I said before, my wife is more hopeful than I am, but it may be something that I don't think it's something that's going to be taken away by either the governor or the legislature.
When would you like us to start answering questions, Samantha?
Yeah, so good point. I was just going to do a quick polling question, and then if you could dive in and answer the rest of the questions that we have. So Lindsay, if you could bring up that third, there we go. What topics would you like to see covered in future AHP-NJ programs? I think everybody can read the screen. I won't read the options. I would just like to say again that Affordable Housing Professionals New Jersey is a fantastic organization, and we do ask our members to join our program committee to assist us in bringing these programs like this one to you.
Okay, Samantha, how would you like us to do this with the questions? Do you want me to just read the questions and then answer them, or do you want to read?
Sure, I think that's fair.
Okay, so the first question, I apologize in advance if I butcher anyone's name, is from Stephen Weinberg, and that question is learning about the New Jersey Municipal Affordable Housing Process incorporated into the certification process for NJ Municipal Administrators, Clerks, and CFOs. I don't know. I don't know, but we can try to get you an answer on that. And so if we could table that one, I am not certified as that, so we can try to circle back on that.
I would like to just point out, again, Affordable Housing Professionals of New Jersey, we work with Rutgers with a affordable housing program. Mark Leckington, who is on our board, if you would like to reach out to him, he could give you much more information. But this program is specifically designed to teach you all about affordable housing in New Jersey, and it's geared towards administrative agents.
Okay. Do you have his contact information, or is there able to?
I will put that in the I will put that in the chat.
Perfect. Okay. The next question is from an anonymous attendee. Fair Share Housing Center agreed to having a brownfield site in the RDP. Was this part of a durational adjustment? I'd have to see the whole settlement agreement, perhaps. I mean, maybe, I don't know.
Most
A
likely.
durational adjustment is when you're getting an adjustment on like a vacant land. It's a capacity issue. So if you don't have enough sewer or water, you can get a durational adjustment. It's functions similar to a vacant land adjustment, but instead of being land being the thing that you're adjusting for, you're adjusting for capacity. So perhaps if you send me the community that you're looking at and their settlement agreement, I can certainly answer that if I have more information. Anonymous attendee again, are any experts in quotes starting to calculate R4 obligations using the Jacobson methodology that towns can use as a guideline for what they can expect? I haven't seen any, but I would be surprised if not. I would imagine, I'm not sure if Mr. Redding is, I spoke to him last week. I'm not sure that he is looking for that assignment again in R4. But I would imagine that Fair Share Housing Center is at least probably starting to consider or crunching those numbers and what that looks like.
Yep.
Great question.
It is a good question. How about sewer and water capacity? A lot of towns have no capacity left after round 3. Can a court force a town to improve their infrastructure or even build a new treatment plant? Jeffrey Long. So Mr. Long, that's a situation where I think if there is no capacity in your town, you would certainly be ripe for a durational adjustment. That's why the durational adjustment process exists, because they can't, if you don't have sewer and water capacity, they cannot force you to build what you don't have. So
one proviso, if you are a town next to a town that does have capacity, you can be forced by the court to hook into that extra capacity. So that is something just to keep an eye on.
So if you don't have the capacity yourself and capacity is available through another municipality, you'll have to consider that. But if capacity is available, whether it's in your town or not, you're not going to be able to get a durational town. If you have no capacity and can't get capacity, then you would be a proper candidate for a durational adjustment. Here's another anonymous attendee. If a town is utilizing a realistic development potential figure to assist in meeting its need, so then you would be a vacant land adjustment town. So you would get to your RDP if you were a VLA, but a larger sized parcel became available since 2015. Will there be pressure to put a large amount of affordable housing units on the site? Or can a small 8 to 10 unit project with a set aside be okay if that's what the municipality determines will fit in the neighborhood? So there is a lot of good stuff to unpack in here.
Yep.
So if the town is utilizing a realistic development potential figure, then you're a VLA town. So if you participated in that ICL seminar that I was on a few weeks ago, the subject of that was, do we need to wait to 2025? So will there be pressure to put a large amount of affordable housing units on the site? I would say there will be pressure to utilize that site for sure. A large amount of affordable housing units. This process is not meant to change the landscape of a municipality, right? Like the courts were clear that, that's why we had caps on the number of units you had to build in any one particular round. And said, would it be okay with that municipality if it determines will fit in the neighborhood? I mean, so you're certainly going to look at other sites in town, what those sites are put in at density, the presumptive minimum density of 6 or 8 units to the acre. So I think to answer your question, it sounds to me like you best be talking about not if, but what that site looks like in your plan and coming up with a reasonable and defensible density. If everything in your plan is between 8 and 10 units to the acre, do you need to put this in your site in your plan at 32 units to the acre? I don't think so. I think, you don't have to try to solve for your entire obligation on this site, but it has to, in my opinion, it would have to be looked at with a reasonable density. So I hope that answers your question, anonymous attendee. Dominic Campbell, is the midpoint review mandatory or recommended? It is mandatory. Yep. It is recommended that you go back and look at it often, but it is mandatory that you do it. Okay. Dan Levin, do people think there's going to be adjustments to the percent in spending plans for affordability assistance? Other changes to budgeting and spending plans? So if by people you mean me, I think there will be, because I think, like I said, we are already being approached from developers, whether it's 100% affordable housing developers, whether it's as of right developers, who are struggling to even put the plans, to put the projects together in place for things that were inked, in 2015, 16, and 17, given interest rates and supply chain issues. So I do think that there is going to be adjustments in spending. I think we're going to have to look at that, right? One of the polling questions that Samantha just put up is facing post-pandemic affordable housing issues, and I think that that's going to be one of them. I'm answering all the questions here. I'm not even letting Michael get a word in edgewise.
It's normal. It's normal.
Michael, do you want to read the next question?
Okay.
We're on Diane.
Yep, Diane, yep.
Isabel and Gloria.
See, she's already answering that one. So does each town have a special master, or is the special master for the judge in that region? So again, most towns have a special master, but as I said, many have retired. So you may have a special master, but that special master is not even around anymore. I know one that's not even in state. Actually, several that are not in state. So yes, every town should have a special master. The courts, and again, just to go back to the courts for a second, as many of you have heard, we don't have enough judges right now. Hopefully we will be getting more and more, and they're working hard on getting that done. We don't have enough judges right now, and the judges are not focused on this issue right now. But some are looking at it, and they want to put special masters in place. So again, as I recommended before, if you have a town and you've got an active affordable housing situation, make sure you do have a special master in place. Again, shameless advertising for my.
It doesn't have to be the same special master for a judge. Like, for example, Judge Rogan has Joe Burgess and I handle a lot of his towns. There could be other judges that have 3 or 4 different special masters, because some special masters, for whatever reason, conflicts or whatever, might not be able to work in every district. So each town should have its own appointed special master, but a judge may have 3 or 4 different special masters working for him. And then, yeah, go ahead.
Okay,
Hi, Peter.
Peter Vandekoy, my
Peter.
friend over at CME. Peter asks, oh, he's not at CME anymore. My apologies. Could you please share your thoughts about the extension of expiring control opportunities and credits? This is a great opportunity to help your plan. If you can extend credits and controls on any unit possible, do it. In some of my towns, we have a form letter that we send out. We have all the units that are about to lose their coverage, and we send a letter out. It's a very friendly letter, and we tell them all the benefits of continuing to have those controls on the site. I have several of my towns. We have large condominium complexes, and the people that keep their controls are able to keep their administrative costs down, and of course their rental or their ownership costs down. So again, you really want to push getting those on board as much as possible. And if anyone ever needs that form letter or anything like that, please feel free to contact me. Did you want to continue on with that?
No, that's fine. That's good. Gail Glasshoff. Lebanon Township is in the preservation zone of the Highlands, 99%. We are 32 square miles. We have only 9 acres that's in planning. How do we do any real affordable housing? That's a really fair question. One of my towns is in the Highlands, Ringwood. I think it's going to look at capacity. We had a meeting with the Highlands. I think that they understand and they appreciate the process. So you have to look for those sites perhaps that have existing impervious coverage on them. With 9 acres, it shouldn't take you too long to go through that exercise. So if you have sites that already have impervious coverage, that to me would be where you're first going to look. But if you have another site that you think that there is a developer who might be ready, willing, and able to do a package plant, my first advice would be look for sites that are already developed, disturbed with impervious coverage. My second would be go to the Highlands, ask them to have a meeting and vet what you want to do, and see if there's a way you could get to the end line with creating affordable housing. And
remember, this just doesn't apply to Highlands. For my good friends down South Jersey, and Parker McCay is more of a South Jersey firm, but remember the Pinelands, it has the same impact upon a lot of these towns as well. A lot of it is preserved. The intent of both Highlands and Pinelands is to preserve the aquifers in those areas. They're highly environmentally sensitive. And you'll also find this situation with a lot of the coastal areas as well.
And the last question is from an anonymous attendee. Will there be any new forms of pressure put on towns in 2025 who still have no settlement agreement and clearly have land plus an unmet need? So I'm going to defer that question to K-Hov, Toll Brothers, D.R. Horton, Lennar, and Pulte. And I'm going to say the answer would be a resounding yes, we're coming for you. So on behalf of those developers and any others, yeah, you have huge exposure.
Yeah.
If you are a town in 2025 who has no settlement agreement and you have land, and I think, you know, we in the industry throw that term out there, vacant land. It is not just vacant land that you have to be considerate of. You have to consider the golf ranges that have gone dark, the tennis clubs that have gone dark, facilities that are vacant or underutilized.
A lot of church properties.
Absolutely. So if you are sitting there, if you're a town who's sitting on lots of vacant and underutilized parcels, in my opinion, you're a sitting duck for the next round.
There is I think there's several law firms out there will remain unnamed, but just so you know, I know one in specific that literally sends out notices to their developer clients that have a map of New Jersey and has a crosshair on each municipality that's in this situation.
Mm-hmm.
So if you think you can sneak by and quietly, no one will notice you, you are wrong. And
if you've gotten to that point so far, I mean, I would be nervous. I would be nervous that at any given day, you're going to get an email or a phone call and you have an enormous amount of exposure.
So I think this is a good time for, our last poll question, which has come up. What is your opinion on utilizing the virtual format of AHP&J programs? We talk about this a lot, post-COVID. Folks got used to doing virtual programming. And I think there's a lot of back and forth as to should we keep up virtual, because it does seem to really open it up to a lot of people that can't get in person.
I just want to remind the registrants that once the program has ended, there will be a survey afterwards that will open on your screen. So leave your web browser open so that you can take that survey and provide feedback on the program. It's just one question. It's very quick.
Thank you, Lindsay. So I will take this time to really say thank you. You guys are the dream team. I have to say, this was so informative, and I'm honored to be a moderator of this. I would like to give a shout out to Lindsay, who you just heard her voice on. She does an amazing job as our administrator, putting these together, working with our program committee. And we hope to bring you a lot more programs in the future. And with that, if there's any other questions, we could answer a few more questions, or you could give us
a quick shout out to Brian Rappaport too, who really worked hard on this.
Oh yes, Brian is our new chair of the program committee, who really put this all together and will be a big part of the programming going forward for HP&J. So we're super excited about that. And if you guys have any just last thoughts to share with us, feel free to give us those thoughts.
Just to finish up, again, just to reiterate, plan, be creative, think outside the box, engage the community, engage the developers, engage fair share housing.
And don't lose sight of the good work that we're doing here. We're creating affordable housing for workforce. I love to think of it as workforce housing. We're creating housing and housing opportunities for people who are working in the state every day, doing, important jobs and giving people better living arrangements and better, and more hopeful living situations. So keep that in mind as we actively try to solve for these problems, that every time we do and we bring units online, we're hopefully improving the lives of people who live in the state, which is really what we're all here doing this for.
Couldn't say it better, Christine. Thank you.
You're welcome.